Jamal Whitehead, Biden 2023. So he's been a federal judge for 2 years, lifetime appointment. But he's only been on the federal bench for 2 years. And he ordered Trump not only that he couldn't get rid of any of these temporary protection status, third world migrants in our nation, but that he had to continue to allow more in. If some of these third world migrants were not yet in America, but had planned to come, the unelected black-robed tyrannical inferior district trial court judge, Jamal Whitehead, ordered Trump to continue to allow them to come in, which would have been tens of thousands. Because, of course, they're all going to say, oh, yeah, no, I had plans to come. So the great and powerful President Donald Trump just scored 2 more huge federal appeals court victories, and he did so in 2 of the most liberal federal circuits. The first Court of Appeals out of Massachusetts and the 9th Court of Appeals out of California. And these 2 decisions both focused on whether the president had the legal authority to end temporary status on third world migrants from Cuba, Haiti, Nicaragua, Venezuela, some of whom have occupied our nation for decades, for 20 years or more, all the while consuming scarce American resources, including housing, education, healthcare, employment, social services, and more, like the human locusts they are, and whether Trump has that authority to re-migrate them home, even if an unelected black-robed tyrannical federal inferior district trial court disagreed. And the answer is yes. All right, so this is Pacito versus Donald Trump. 3 judges, 3-judge Court of Appeals panel. 2 of them were Bush appointees, and one of them's a Trump appointee. So there's really 2 issues here. One, in this case, is one, the ones that are here, does Trump have to continue providing them with support, with scarce American resources? And unfortunately, this 3-judge panel in a 2-to-1 vote says, yeah, if they're here, Trump has to keep providing them with resources. That's not great, but we can circle back to that later. They're still here on temporary status. We'll get rid of them eventually. More importantly, what this 3-judge panel ruled, and on this they were unanimous, that Trump cannot be compelled to allow more of these people in, these third world migrants, simply because they say, oh yeah, I was definitely planning to come. So that part of Jamal Whitehead's order to Trump is overturned here, is stayed, is frozen. It was, of course, a preliminary injunction, as so many of these are. So let me grab my red pen. Pacito versus Trump. Clifton, Bybee, and Lee. This is a 3-judge Court of Appeals panel, and there's a partial dissent by Lee. And again, these are Bush, Trump. These judges, 2 of these judges are going to say Trump can keep out new ones from coming in, but the ones who are here are dependent on the support the federal government's been providing, and we're going to order that to continue. Lee would have said, FM, Trump gets to cut off the support too. So Lee was dissenting in this opinion in a direction even more favorable to Trump. Not bad for a 3-judge panel out of the 9th Circuit. So the judge is right. We heard oral argument in this case on an expedited basis on September 3rd. An opinion on the merits will issue in due course, but in the meantime, this order shall constitute a stay, so a freezing of the order against Trump by the unelected black-robed tyrannical inferior district trial court judge Jamal Whitehead, class of Biden 23. We hereby vacate our administrative stay. A lot of boilerplate here. The point is they're issuing an order in favor of Trump and against the trial judge who had ordered Trump to allow tens of thousands of more of these third world migrants into the country. On January 20th, 2025, the day that Trump was sworn into office, he issued an executive order entitled Realigning the United States Refugee Admissions Program. Pursuant to 8 U.S.C. 1182 and 1185, the president determined that the entry into the U.S. of refugees under the U.S. Refugee Admissions Program would be detrimental to the interests of the United States, and directed that entry into the U.S. of refugees under U.S. RAP be suspended. On January 24th, the Department of State suspended all funding of the U.S. RAP program, pursuant to a different executive order reevaluating and realigning United States foreign aid. This suspension included funding for domestic resettlement services for refugees admitted to the U.S. We got to end all this refugee stuff, folks. It's one thing to send them aid in their country. We got to stop bringing these people into our nation. The plaintiffs here are refugees who were previously admitted to the U.S. and have been approved for resettlement, but remain outside the country, and 3 organizations that had cooperative agreements with the State Department to provide overseas processing for people applying for refugee status and resettlement services for refugees admitted to the United States. So 2 groups of people. Some of them have not yet gotten to the U.S., but they claim the U.S. is supposed to provide them with money and support to get here, and others who are already here and being supported by the federal government. In February 2025, the plaintiffs filed the lawsuit, Western District of Washington, federal court, alleging that the executive order suspension of the refugee program violated the Refugee Act of 1980, and that the defunding of USRAP violated various provisions of the Administrative Procedure Act. Oh, the APA is back, folks. These left-wing progressives suddenly love the APA. As I've explained every time, the Administrative Procedure Act was created to protect the American people from the overreach of independent government agencies. But now that Trump's in office and all the left has are these rogue, unelected, black-robed, tyrannical, inferior district trial court judges, suddenly they love the APA that was intended to hamstring their progressive independent agencies. Suddenly they love it so they can use it in the opposite way if it was intended. It was intended to protect American citizens from progressive agencies. They're using it now to protect progressive agencies from the political will of the American people. On February 25th, the District Court of Jamal Whitehead, Biden class of 23, orally issued a preliminary injunction prohibiting the enforcement or implementation of that executive order. On February 26th, the government terminated every cooperative agreement to provide reception and placement services for refugees in the U.S., and all but one of the cooperative agreements to provide refugee assistance programs abroad. So cutting off help at home, cutting off help abroad to get them here. On February 28th, Jamal Whitehead, the district court, issued a written order defining the preliminary injunction, specifying it also prohibits the suspension of refugee assistance program funding. So now this federal judge, Jamal Whitehead, is assuming Article 2 executive branch powers. He's become the head of the U.S. Refugee Assistance Program. On March 25th, Jamal Whitehead issued a second preliminary injunction ordering the State Department to reinstate all cooperative agreements terminated previously, and the government appealed. Remember what a temporary restraining order and a preliminary injunction are supposed to do, folks. First of all, they're supposed to be extraordinary remedies. Is the rate at which they're being issued against Trump, does that feel extraordinary and rare to you? No. When it's Trump, they're issued against him like candy. But also, they're supposed to freeze the status quo. They're supposed to freeze things where they are so they can't get worse. But how does the left use temporary restraining orders and preliminary injunctions against Trump? By ordering him to do things to change the status quo, reinstate things, begin funding again. The government sought a stay of those ridiculous orders from Judge Jamal Whitehead. Now, let's see. And that got to this 3-judge panel, Court of Appeals panel, quoting Trump versus Hawaii. We observe that the authority under which the president issued his executive orders exudes deference to the president and vests him with ample power to impose entry restrictions in addition to those elsewhere enumerated in the Immigration and Naturalization Act. We denied the motion for a stay of the trial judge's order, however, to the extent that the trial judge's preliminary injunction applies to individuals who were conditionally approved for refugee status to the U.S. before January 20th. So the trial judge said, hey, not only do you have to keep the people who are here, but if people not yet here were conditionally approved to come here, you still have to let those in. And when this first got to the Court of Appeals, the Court of Appeals decided not to change that order. The Court of Appeals was going to let that preliminary injunction stand, meaning that Trump would be compelled to bring tens of thousands of additional third world migrants into the country. Fortunately, following briefing, but before argument, the district court issued another order to establish a framework for enforcing a limited carve-out and appointing a magistrate judge to oversee the framework. Again, this is Jamal Whitehead, the trial court judge, taking over U.S. immigration process. This framework they're talking about here is basically Judge Jamal Whitehead, Biden 2023, establishing a parallel immigration and naturalization authority under him that would be assigned to a magistrate judge, a junior judge that would report to Jamal Whitehead, who would now be in charge of the temporary protection status immigration program. Trump filed an emergency motion to amend that order on July 17th, 3 days afterwards, and on July, it sounds like a weekend. Was July 14th a Friday? No, it was a Monday. Okay. Anyway, the same week, Trump filed an emergency motion to stop this craziness, not allow the judge to set up his own immigration authority. And the following day, the day after Trump's emergency motion to the Court of Appeals, they issued a stay of that Monday enforcement order. And we scheduled oral argument on an expedited basis. Like even they recognized this Jamal Whitehead, unelected black robe, tyrannical inferior district trial court judge, was off his gourd. In light of the briefing by the parties and oral argument, the case is submitted for decision. An opinion on the merits will issue in due course. In the meantime, we now vacate our administrative stay of July 18th and our stay of March 25th, and as amended, blah, 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 blah. And we issue this stay pending final resolution of this appeal on the merits. The orders of the unelected black robe, tyrannical inferior district trial court judge Jamal Whitehead, Biden 2023, are frozen, except as noted below. The standards for issuing a stay of an injunction are essentially the same as for issuing an injunction in the first place. Only the first two really matter here. Likelihood to succeed on the merits and whether there will be irreparable injury if the stay is not issued. So Jamal Whitehead, the trial judge, said the third world migrants meet these conditions. They're likely to win on the merits, and they'll be irreparably harmed if the preliminary injunction in their favor and against Trump is not issued. This three-judge Court of Appeals panel is doing the same analysis, but from the perspective of Trump asking for the preliminary injunction to not go into effect. And this three-judge Court of Appeals panel concludes that Trump is himself likely to win on the merits and would be irreparably harmed if this three-judge panel does not freeze the lower court's injunction ordering Trump to let in tens of thousands more third world migrants. Of these factors, the first two, the showing of success in the merits and irreparable harm, are the most critical. This three-judge panel concludes the government, Trump, is likely to prevail on the plaintiff's challenge to the validity of the executive order suspending refugee admissions, and we cannot engage in a searching inquiry into the persuasiveness of the president's justifications. If the president has a reason, they have to defer to his reason. Requisite set forth in 1182 is that the president find that the entry of the covered aliens would be detrimental to the interest of the U.S. That's all he needs to be able to stop more coming in and the president has undoubtedly fulfilled that requirement here. The language of 1182 is clear, and the executive order does not exceed any textual limit on the president's authority to suspend the entry of any class of aliens into the U.S. For reasons to be explained in full in an opinion to follow, however, the government is not likely to prevail, according to this three-judge panel, on at least one of the plaintiff's challenges under the Administrative Procedure Act. Under a different statute, 1522, the government must provide certain reception and placement services to refugees after their admission in the U.S. So far, they've decided Trump can stop new people from coming in under TPS. Now they're addressing, but what about the people already here? Trump has cut off their funding for refugee assistance support. Section 1522, and this is two of the judges are speaking now. This part is a 2-to-1 decision. Section 1522 requires the director of the Office of Refugee Settlement, to the extent of available appropriations, to make available sufficient resources for employment training. Look at all the things we do for these third world migrants invading our nation. For employment training and placement, so they're taking American jobs in order to achieve economic self-sufficiency. Why do we want them to achieve economic self-sufficiency? Aren't they only supposed to be here on a 2-year temporary basis? Provide refugees with the opportunity to acquire sufficient English language training. Again, I thought it was temporary, their stay. Why do they need English if they're going back home where they speak Spanish or French, I guess, in Haiti, whatever they speak in Haiti? Ensure that cash assistance is made available. So they're getting cash money. Thank you. You're welcome. Ensure that women have the same opportunities as men because, all these Cuba, Haiti, Nicaragua, Venezuela, we all know that they're egalitarian societies between the genders, right? Similarly, with respect to unaccompanied minor refugees, the same statute provides that while such child is in the U.S., or in transit to the U.S., but before the child is so placed, the director shall assume legal responsibility, including financial responsibility, for the child. With respect to cash and medical assistance, remember, I always say these third world migrant invaders are consuming scarce American resources like human locusts, healthcare, housing, education, employment, social services. This is it, folks. And there are hundreds of thousands of just this category of third world migrants in the United States, and hundreds of thousands more that would have come under this program under Biden. That's what Trump is stopping. With respect to cash and medical assistance, the statute provides the Secretary of Health and Human Resources shall develop projects for refugees who have been in the United States less than 36 months. So that's 3 years. So they have 3-year programs for what's supposed to be a 2-year stay. That's nice. To provide interim support, medical services, support services, case management. For fiscal year 2025, Congress has appropriated $3 billion for this. Unbelievable. $3 billion. Section 1523 requires accountability in the form of detailed reports on how the spending is being used. By statute, these resettlement services often referred to as reception and placement services. That sounds nice. I guess they don't want to call it giving away $3 billion of my money services to third world migrants who hate us. These settlement services may be provided through the use of contracts, grants, or cooperative agreements with public and private nonprofit agencies. These are NGOs. These are all money laundering operations, folks. All these kids of wealthy families around the District of Columbia in Northern Virginia, all these kids who graduate college with gender studies degrees and other degrees of zero or negative economic value, they all get hired by these NGOs, get fat salaries so they too can live in Northern Virginia and live fat on the land. And maybe 10 cents of every dollar in these grants ends up going to the people who supposedly need the support. It's all money laundering. The United States has historically, until Trump, entered into cooperative agreements with various resettlement organizations to provide such services. This is the money laundering. The organizational plaintiffs, the people suing in this case, are 3 such organizations that had these agreements that Trump ended. In February 2024, the State Department terminated all cooperative agreements to provide such services. So this is during the Biden administration. Acknowledging such termination of funding for resettlement services, the government advised Jamal Whitehead on March, I think this might be a typo. I think this might be supposed to be February 2025. So the Trump administration, because this happened a month later. Makes more sense if this is February 2025. The trial court of Jamal Whitehead, Biden 2023, was advised by Trump on March 10th that it was actively preparing a request for proposals for a new resettlement agency to take over from the ones that had fired. Despite that representation, the government advised this Court of Appeals 3-judge panel at oral argument that it was unaware whether any progress had been made towards securing new agencies to provide reception and placement services in light of the government's uncertainty regarding its ability to provide reception and placement services statutorily mandated. The government is hereby directed to reinstate those agreements necessary to provide those services to refugees who have already been admitted to the U.S. Such services shall include the usual and customary services that have been afforded such refugees under the prior service agreements. So that would be housing, healthcare, education, employment, social services, and all the rest still has to be provided to these temporary people who are still in the U.S. What's being ended here is the bringing in of new ones. Trump doesn't have to bring in any more just because they say, oh, we were planning to come, which is what the lower court had ordered. Now, this part of this decision is the 2-1 part. So it takes legal effect until Trump appeals it to the Supreme Court. But the dissent here disagrees with this. The dissent would have stopped new TPS migrants from coming in and allowed this funding to be ended. This is the Trump judge, Lee, in dissent on the issue of whether the people who are here have to keep getting provided with resources. He writes, even though the president enjoys vast discretion and deference in immigration matters, the unelected black-robed tyrannical inferior district trial court judge Jamal Whitehead incorrectly enjoined Trump from implementing his policy decision to limit admitting refugees and providing services for them. I would freeze that unelected black-robed tyrannical inferior district trial court judge's orders in their entirety. So stop new migrants from coming in under this program and stop paying for the ones already here. My colleagues, the other 2 judges on this 3-judge panel, my colleagues and I agree the president has the authority to impose a moratorium on new admissions of refugees. But we disagree on whether the federal government has a legal duty to provide services to those who were recently admitted before the suspension of entry went into effect. My colleagues interpret the statute as requiring the government to provide certain services to refugees. To my eye, the provision is most naturally read as an authorization, but not a mandate. We start at the beginning. The statute's title is Authorization for Programs for Domestic Settlement and Assistance to Refugees. Authorization is permissive, not mandatory. Quoting Black's Law Dictionary now, authorization defined as permission to do something, or the official document granting permission. Congress thus allows action. It does not require it. Further, the 4 specific statutory provisions that provide funding for different refugee services, program of initial settlement, resettlement, cash assistance, and medical assistance, all state that the director is authorized to provide assistance. Again, these are statutory signals that the executive branch has discretion over funding, not a mandate. In arguing that the statute imposes mandatory funding, my 2 colleagues look to the statute titled Conditions and Consideration, which uses the word shall and the phrase to the extent of available appropriations. But that language is qualified by the immediately preceding phrase, quote, in providing assistance under this section, that is, the discretionary funding provisions of the statute. In other words, the statute imposes certain mandatory conditions and considerations if the government chooses to fund refugee programs. For example, the director shall make available sufficient resources for employment, training, and placement under the statute's discretionary funding. In order to achieve economic self-sufficiency among refugees as quickly as possible, this is the mandatory condition or consideration that must be taken into account if the government decides to fund it. To bolster their claim of mandatory spending, my colleagues cite subsections of the statute which arguably impose some obligation on the director. Neither provision, however, persuasively counters the overall operation of the statute. One subsection requires the program's director to take legal and financial responsibility for unaccompanied refugee children only if such responsibility is necessary. The section also authorizes the director to make necessary decisions to provide for the child's immediate care. Even while using the word shall, the subsection drips with deference to the executive branch and invokes no firm mandate. It also is not clear from the record if there are any unaccompanied refugee children at issue here. Similarly, the other subsection, claimed to support the majority here, states the secretary shall develop and implement projects for cash and medical support. Anybody else getting cash and medical support from the federal government? Anybody in this community? As needed. The metes and bounds of the program are up to executive discretion, hardly a congressional mandate. In my view, the statute authorizes the executive branch to craft programs under its discretion as long as appropriations flow. It does not require that those programs operate. As the law does not demand the executive branch provide these services, our court is in no position to mandate them. I respectfully dissent in this part. The part that says Trump has to continue providing support for refugees under this program already in the U.S. I think if Trump appeals this to the U.S. Supreme Court, he wins. I think this is a very compelling argument. So that's the first remigration victory for Trump. He doesn't have to let in hundreds of thousands of more Cubans, Haitians, Nicaraguans, and Venezuelans, as he was ordered to do by the unelected black-robed tyrannical inferior district trial court judge, Jamal Whitehead.